Hello, everyone, wherever you are, whatever time zone you're in. Thanks very much for joining us. This is a panel discussion being held, as you know, as part of the London International Disputes Week. Now, the snappy strapline for the Disputes Week is looking forward, change, challenges, and opportunity. The slightly less snappy strapline for tonight's panel discussion is managing a mixed civil law arbitral panel in international construction arbitration. Now, it is my very great pleasure to be joined tonight by my friends, firstly in alphabetical order, I'll do this, I think, Veronique Buehrlen, Queen's Counsel from Keating Chambers, well known to many of you, I'm sure, sits as often as an arbitrator in international arbitrations and obviously acts as counsel in them. Second, alphabetically, Paul Lowrie, partner at Clyde Co in the, I think it's the Marine and Energy team, Paul, and specializing, I think your bio tells me, in onshore and offshore projects, particular interest in construction disputes, I'm glad to say. Third and last member of our panel tonight is Emily Monastiriotis, who is the partner and head of dispute resolution in the UK at Simmons Simmons. So we have an absolute wealth of talent and experience on the panel, but actually the talent and the experience does not end there, because I'm very pleased that my friend from Atkin Chambers, Samar Abbas Kazmi, is joining us not actually on the panel, but to deal with any questions which you, the audience, may put in, I think, using the Q&A function on your screen. And Samar hopefully will not field them, I suppose. He will pass them to us, the panel, when we're least expecting it. So please submit your questions as we go along. Don't wait till the end. Now, there is one extra thing I should mention, which is that we are conducting a poll. And on your screens, either now or at some point in the near future, a question, here it comes, will pop up. And if you feel like answering it, feel free. It will give us a better idea of who's listening. I suspect I could predict where the preponderance of answers will be, but please do that if you can. So there it is. Let us kick off proceedings, and perhaps we could start, perhaps I could start with a question concerning probably where most most international arbitrations start, which is with procedural orders. And I think it's fair to say that, certainly this is my experience, that tribunals which lean towards or adopt a more civil law approach often seem to come up with what we common lawyers might consider to be rather over-prescriptive procedural orders. Can I throw that out to you, Emily, first of all? I mean, is that your experience? And if it is, does it cause problems, particularly further down the line?
Yeah, thanks, Andrew. I think the starting point are the general rules that are adopted very early on by the parties, and which set out the procedure to be followed by arbitrators and the parties throughout the arbitration. So, for example, in relation to ICC arbitrations, parties are required to draw up terms of reference for the procedure to be followed for their arbitration, and both parties and arbitrators are bound by those terms of reference. Another good example, I think, is the IBA rules on the taking of evidence in international commercial arbitration, because these are rules that have been developed by a committee of lawyers drawn from both traditions. So I think kind of a good balance is struck. But that having been said, from my experience, civil law lawyers do appear to be more focused on procedural orders. They're very focused on perhaps crafting the precise scope of the dispute, whereas common law arbitrators seem happier to adopt kind of broader wording in the knowledge that disputes often morph into different areas as they develop. Now, is that a problem? I suppose which approach is more appropriate and helpful really largely depends on the nature of each case, but from my experience, I think the more complex the case, the more likely it is to evolve. So I do think flexibility is needed, but obviously I say that from an angle of a person who deals with complex international construction arbitration. So flexibility really is key.
It is, but I mean, I'm thinking particularly, say, of hearing protocols and the like, which I don't think I'm exaggerating if I say I've seen them run to 30 or 40 pages in immense detail. Paul, what's your take on this? Is that really helpful, or does it cause more problems than it solved?
Well, I mean, I've certainly seen some, where perhaps there's sort of more of a civil bent to the tribunal, where sort of in the very early stage of the proceedings, the panel is appointed, and sort of immediately the parties are presented with sort of a 20-page set of rules, which are almost that tribunals or one of the arbitrators on the panels sort of own personal set of rules. So it's like having an LCIA or ICC sort of set of rules in addition to the procedural rules, and a lot of those becoming very sensible things, and genuinely can is getting the parties to think early on about procedural things that could become a problem in the future. But sometimes I just feel that when you're presented with that very early on, that there is a risk that of the parties sort of being railroaded into this, and this is a consensual process, and when you're presented with something clearly with the idea from the panel that you're going to agree to this, if you want to push back, you've got to be all a bit sensitive, particularly if you don't. You've really just got to try and get the other side on board, really, and do it together.
If the other side is very much in favour of what I'll call the prescriptive approach, and as you say, it's the personal sort of list that one of the tribunal pulls out of his pocket every time, then pushing back against that's a little bit tricky, I think, especially if it's perhaps your first meeting with the tribunal. You don't really want to appear to be obstructive. I guess one of the first things which then gets decided, and I'd imagine this is ought to be consensual, but it isn't always, is whether the approach in terms of the presentation of the case is going to be memorials or pleadings. And Veronique, perhaps I can ask you this: is one better than the other, or is it a question of horses for courses, and some cases are more suited to memorials, some to traditional pleadings?
A bit of an eternal debate, isn't it, as to which is best? I mean, I think that in relation to memorials, there are certainly arguments about increased costs, increased time, a failure to perhaps identify the issues until quite late on in the process of exchanging memorials. And against that, of course, you have the fact that at the end of the day, the civil process has often recognised that you should put your cards on the table right from the outset of the process. What I found in relation to that, and I'm sure this is a common experience, is that I think we're moving towards more of a hybrid type situation. So more and more in recent years, I have seen, both obviously as counsel and as an arbitrator, parties agreeing that what they're going to do, for instance, might be pleadings, but with rely upon documents, and not just the contract, but really the documents, the emails, whatever it is that is referred to or relied upon in the pleading. So I think it's that move towards a hybrid process, and it's more and more common, obviously, if you've got a mixed tribunal, to be doing that.
Yeah, and I've certainly seen that increasingly. And in fact, I think I'm right in saying it's written into the Hong Kong International Arbitration Centre domestic rules that with your pleadings, you should serve I think the way it's expressed is the essential documents relied upon. Now, the trouble with that is what you may think is essential, I may not think is essential. And so the selection of documents that you tend to get can be rather selective. and to that extent, it's less helpful. But
Yeah.
and I wonder what Emily and Paul think of this. I mean, is there a sort of generally in sort of procedural matters some sort of convergence happening? That's to say, the good bits of the common law system and the good bits of the civil law approach seem to be being picked out and then merged together.
Can I jump in on that with a question from the
Samar,
audience?
yes.
On the hybrid approach, where does the panel draw the line between where pleadings end and memorials begin? If we are to talk about a hybrid approach, and what exactly do we mean when we say exchanging memorials, for those who may not be?
I think it's a very good question. So my two penneth is, as Veronique has said, I mean, there's very much sort of a hybrid approach now, with sort of pleadings that look a bit like memorials, and maybe the other way around too. But for my mind, I mean, there's a clear dividing line between attaching documents to a pleading by way of reference, and sort of attaching more than that. So if you're attaching witness statements, if you're attaching sort of expert reports and all your other forms of evidence to your to your statement of case or defence, then I would say that's more of a memorial approach, and sort of that's where the line is crossed.
I'd agree. I think there is a line between attaching documentary evidence and attaching what is witness evidence, whether that's going to be whether that's a factual witness or an expert witness.
Yeah.
But
no, I'd agree with that. But I think you've also got to remember that there's a difference, or strictly speaking, there should be a difference between a pleading and a memorial in terms of the actual submission. When you're doing a pleading, you're supposed to limit yourself really to the bare bones of what it is that you're saying in terms of your cause of action and so on, whereas a memorial is much more of a submission and tends to be lengthier. So even the core document is different.
If I think of all the pleadings I see in sort of large infrastructure disputes, they are never cut back to the bare bones at all. They're often very lengthy. That doesn't mean they're particularly informative.
Andrew, fair point there.
It doesn't mean they're informative, but they often go on and on and on.
Well, I'd like to think that my pleadings don't.
Veronique, I'm sure you are a paragon of virtue when it comes to pleading. But my own view, I think, is that certainly in big infrastructure disputes, memorials don't work, or don't work very well.
It's difficult, isn't it? I mean, when I'm sitting, I will give the parties the choice. I think it's a party-led. It can be a party-led choice to say from the outset to the parties, when you're proposing what procedure do you want to adopt, to give them the choice as to whether or not they want to adopt a pleadings-led approach or a memorials-led approach. Because as Paul says, it's a consensual process.
I'd be very welcome to that sort of approach from the tribunal.
That's fine, but Emily, what do you do if there isn't a consensus? One side thinks it should be memorials, and one side thinks it should be more traditional pleadings, perhaps with rely on documents. How does the tribunal then decide?
Well, that's often the trick, isn't it? Particularly with mixed tribunals, where you can see which way they kind of tend to lean. But I'm absolutely with you. I think it's very, very difficult to kind of go down the very strict memorial style when it comes to large infrastructure, large construction disputes, and kind of drawing the line that Paul was talking about earlier, where you append kind of the key documents is I think probably the most realistic way forward. But just because the key issue that you have in complex construction arbitrations is you're very reliant, aren't you, on expert evidence, and that can change and that can evolve, and cases can change and evolve, and therefore the memorial style, I think, is just not suited.
Yeah, I mean, we're going to come on, I hope, and have say a few words about expert evidence later. But can I pick up one point, one aspect of certainly what used to be, I think, considered to be expert evidence, which was evidence of foreign law. And Paul, this I know is a matter close to your heart. Is there a change there that now we're seeing foreign law not really treated so much as a matter of evidence, but really as a matter of submission?
I would entirely agree with that. You know, I had an arbitration a couple of years ago where there was actually, you know, there was a difference in approach between the parties. You know, we were doing it purely on submissions, whereas the other side were doing it on a mix of submissions and expert evidence. And you know, in was wheeled a very eminent professor as expert in this particular country's legal system. And I must say the tribunal was a little perplexed, really. You know, particularly when sort of one of the tribunal in this sort of mixed tribunal was an expert in that particular legal system. So I think they were just a little sort of surprised, really, to be being sort of, you know, told by this eminent person, you know, the law on this particular area that you know they were rightly an expert in. So I think
that had been legislated for in the directions, in the procedural orders earlier, though.
Undoubtedly, I know they certainly had permission for it, and you know the tribunal's view was, you know, if you want to put in this evidence, well, you know, that's you're thoroughly entitled to do that. But you could tell from the reactions from the tribunal that, you know, this wasn't really advancing sort of anyone's understanding particularly, and the fact that, you know, when you read the award there was little if any mention of this particular evidence in there, shows, I think, that in that particular example it wasn't necessarily the most helpful approach in terms of you know, persuading the tribunal to your way of thinking. But, you know, my own sort of, you know, my own approach, and sort of speaking to colleagues, you know, certainly sort of shared by them, is that, you know, we are going to sort of, you know, more of a submissions approach, which makes some sense, really, because obviously there is no foreign law really in international arbitration. It's not like making submissions to the English courts in front of an English judge. So, you know, submissions do make more sense, and they're a bit nimbler, I think. But I think the trick is knowing, you know, what submissions you can make, and, you know, what submissions really should be being made by someone else. So, you know, there are sort of, you know, it might be, you know, there are particular legal systems and issues within those legal systems that, you know, that we as common lawyers, you know, even if they're not English principles, are very familiar with, and similarly for the tribunal. But, you know, if you're straying off piste a little bit and getting into slightly, you know, sort of, you know, more esoteric sort of law, legal systems, then, you know, perhaps that's the time to bring in a co-counsel.
Let me ask Veronique, especially when you're sitting as arbitrator, how do you have a preference for how questions of, I'm going to call it foreign law, are submitted to you or addressed to you?
I don't have a particular preference. What I was thinking was a couple of things. One is that I think it in part can depend on the nature of the issue, the legal issue that you're dealing with. Yeah. Because when we were talking about this generally earlier on, I was thinking Paul's absolutely right, that in my experience, there's more, particularly on very big litigation, there's more and more mixed teams of counsel. And, you know, I've been brought in as counsel on cases where the seat is not in London, but where the applicable law is English law. And obviously have had foreign counsel come in where the seat is in London, but the applicable law is a foreign law to ours. But one thing that occurred to me was that, in fact, next week I'm doing an arbitration, sitting as an arbitrator, which is not a mixed tribunal, but on which there is expert evidence of the applicable law, which is a foreign law in terms of a London seat. And it made me think about it and realize that if you're dealing with a very specific point, so say it might be something quite recherche, like about assignment or something like that, you might see a situation in which you were more likely to go for the expert approach than the mere submission approach, possibly. Yeah. Whereas I think that if you're looking at, you know, the law that's applicable to the overall contract on a bid infrastructure dispute, then you're more likely to go for a co-counsel approach, assuming that you actually need any evidence of the foreign law, because we know also that if you've got a seat in London, of course, one of the things that if you don't submit that the law is any different, then we just all assume that it's the same as our own
very British approach, that.
So it all rather depends. I think Emily's got some views as well on this, because
yeah, I do think kind of Paul's description about it being a minefield is absolutely true, because I just don't think there is a uniform approach. And personally, that's why I think it is important in the right case to co-counsel with someone from the relevant jurisdiction, because otherwise you end up with a very broad foreign law principles for someone who doesn't know enough about the detailed background on the case.
Yeah. Right, well, let's move on from foreign law and look at a different aspect of evidence, and particularly in documentary evidence. And certainly, I think the traditional view is that in determining the facts, at least, civil law tribunals place much greater emphasis on the documents. And on evidence. Others may disagree, but I'm sorry?
You were breaking up then.
I was breaking up.
Or at least on mine.
Yes, so Andrew, would you mind repeating that question for us?
Forgive me, yes. It's probably one of the children on Netflix, I'm afraid. I was saying that I think the traditional view is that civil law tribunals place much greater emphasis on the documents in terms of factual evidence rather than on oral testimony. I say that's the traditional view, and I was wondering, let me ask you, Emily, does that still hold view or hold good today, or have things changed?
I'm talking about from one minefield straight into the next one, Andrew. I just think the common law approach, obviously oral testimony plays a very large and important role at hearings, and obviously is kind of a particular high, particularly for barristers like you and Veronique, is the cross-examination of witnesses and experts during the hearing. But you need to contrast that with the civil law approach, where there is more emphasis on documentary evidence, and direct examination by the party's representatives is more limited. And generally civil law rules of procedure require the arbitrator to interrogate the witness first. And frequently that witness begins with kind of a free narration from my experience, but after that then the judge has finished his interrogations, then the attorneys of both parties may question the witnesses, and all of this is usually done in an informal manner. But all that being said, I do think we're now witnessing kind of a converging practice. It's moving on. I think witness statements in writing are submitted generally in advance of the hearings, and the term cross-examination is rarely used in arbitration literature. So the IBA rules talk about testimony and direct testimony, and tribunals do allow counsel for the parties to question witnesses first, but only ask questions in points if there are points in which the tribunal is interested and aren't brought out. So I think we'll see less and less of what you call kind of the traditional cross-examination in mixed tribunals.
Can I ask you this though, as things stand today, does it or how does it affect your sort of preparation and presentation of the case if you know there's going to be less cross-examination and a greater emphasis on the documentary record?
I mean, I think the first thing that anyone ever really goes to are the contemporaneous documents. And it's interesting when you get very, very lengthy witness statements reciting documents or putting a spin on them. So I think documents have always been kind of one of the main pillars of your case anyway. And really, it's kind of a matter of presentation at the hearing itself. Yeah.
Witness statements, I mean, it's a bit of a bugbear of mine, but you know, I increasingly see, I'm sure we all increasingly see longer and longer witness statements, often reciting, you know, as you say, sort of great swathes of the documents. Is that Veronique, is that a good thing? Is it, or is it something we should try and avoid?
Well, I think we all know, don't we? We all sing from the mantra of we need to avoid that. Partly because, you know, from the arbitrator point of view, you know, you don't want to get 200-page witness statements, and you don't want to get 600-page submissions, preferably either, because it's quite difficult to keep the attention up. And it's really important for parties to be able to see the wood from the trees, which, you know, if you're putting in 200 pages witness statements, it's not going to do. I think one of the questions that we've been thinking about was whether or not, you know, the tribunal should prescribe the length of witness statements.
Yeah.
I'm not in favor of that sort of approach, because I do think that that's too prescriptive. And I do think that one size obviously does not fit all. But at the same time, that you need to remember, well, why do the witness statements so often go on and on? And part of that is that there is a tendency to want at least one witness statement that is going to tell the story. Because if you're not going to get the story, for instance, told in a submission, it's very tempting to want to tell the story in, you know, the lead witness statement or something like that. One possibility that occurs to me as I'm speaking in terms of trying to reduce the length of witness statements is that I think tribunals can make noises, so to speak, for instance, at CMCs, along the lines of, well, we don't want to get 200-page witness statements if it can be avoided. Or, of course, to say, well, look, we'd like the parties to actually identify the factual issues.
Yeah, well,
and therefore,
I think on the head there. That's for me is the key to it, and should occur as early as is sensible. That preferably with, and there will certainly be some measure of agreement. There's nearly always some measure of disagreement as to what the real issues are. But I think the sooner that is done, obviously then factual evidence, expert evidence, etc., can be.
I would agree with that, Andrew, in terms of the soonness of it, because, you know, it's if we do have a pleadings approach to this you know, hypothetical arbitration we're talking about, then, you know, giving that sort of instruction sort of after pleadings have been done is you know, a bit late, because if that sort of factual submission is not going to be made in the witness statement, it needs to be made somewhere. So it would be, you know, it should be in the submissions, the earlier submissions.
But of course, Paul hits the nail on the head, which is this is assuming that you've not got a memorial type approach. If you're going to try and define those issues, those factual issues that the witness statements are going to be targeted at, that is not going to be happening in a memorial type approach.
Maybe I'm just unlucky, but if I look at the pleadings that I may have in the case in front of me, as they stand, they're generally, I don't find they're particularly useful at really identifying the issues. I think it's a separate operation, a separate exercise after pleadings have closed for the parties, with the assistance of the tribunal or the encouragement of the tribunal, to say, right, come on, let's at least try and identify what are the principal or the main issues here. It's very useful for the tribunal, apart from anything else, but it's a great discipline for the parties and the lawyers to actually try and work out what this case is really about. So anyway, I'm a great fan of this being encouraged at an early stage. Now I see Samar has joined us, which may mean
I have with a question, because there's a consensus amongst the panelists that long submissions are not a good thing. There's a question which from the nature of the questions put, I believe to be from a civil lawyer, and I'll read it as follows. It is a widely believed myth among civil lawyers that 300+ pages submissions are something to be traced to the common law part of the roots of international arbitration community. What is your view?
Well, let's try Veronique on that.
It's not my experience. So in fact, my experience has certainly been that working with civil lawyers, I have seen much longer sets of submissions than I have seen from common law lawyers. That is my experience. I mean, certainly, and perhaps it's sort of in my old age, I've come to realize, sitting as an arbitrator, just how important it is to try to be concise, because you then really fully appreciate what it's like to be faced with a 600-page submission, where you're trying to then figure out, well, wait a minute, what actually matters here.
Sure.
And
sure.
you know, if you're really doing your job well as counsel, then I think you really must do your best to keep these submissions succinct. And of course, that can be very difficult when you're dealing with a very big, you know, construction case. I mean, I understand that. But really, one should avoid repetition. You know, the idea that you put it in your introduction, you put it in the body, you repeat it again in the conclusion. I think that's like a sort of school essay, and not really the approach that you want to take in
I guess in part people are people's actions are motivated by the confidence they have that the tribunal has got the point. But Emily, tell me, are you guilty of 300-page submissions?
Absolutely not, Andrew. How could you ever say that? And I think actually, in fairness to the person asking the question, given kind of the common background of everyone in the panel, I don't think many people will say that it evolved from kind of common law practice. But I do think sometimes actually it can also be witness-led as well, where witnesses keep saying, oh, and another thing, and you keep saying, well, no, but that isn't actually relevant. Let's work out what the key issues are. And I think a really good practice in international arbitration when you've got mixed tribunals is identifying the key issues early on and really directing your witness evidence and your expert evidence to those key issues. But I mean, I feel very, very strongly that you often end up with these really long submissions that are just not helpful to anyone, and we need to find a way of limiting that.
Yeah. Well, Veronique, one commonly sees a limit placed on submissions, but that's not unusual. But certainly when it's closing submissions, of course, by that stage you've already had the several very long 100-page witness statements, etc., to deal with. But I think there's a consensus amongst us anyway, but I'm sure we don't do this in practice, that submissions and witness statements should be much shorter. We're all agreed.
Yeah. But you're absolutely right.
I'll just get back to my 400-page submission. Yeah.
I think you're absolutely right, though, Andrew, that of course it is all about confidence. It is all about, you know, having the confidence to say, okay, this is my case, and I don't need to make 20 different arguments, which actually are not very good ones. Of course, at the same time, you're faced with that worry that, you know, well, maybe this particular arbitrator or this particular panel would prefer this point to that point. You know,
it's all very good in practice, but you know, in reality, it is very, very difficult to do. You know, or you know, very early in the arbitration to work out what the key issues are, and I think that's why it's done this way, because it's not until you know, again, in that pleading style, you're sort of getting to your witness evidence, you're getting to your expert evidence, that you know, you really sort of getting to grips with what the key issues are here. And you know, maybe sort of, you know, our civil colleagues would say, well, you know, that whole approach would be a lot easier if you did that sort of from the off with a memorial, where you're not kicking the can down the road in terms of your sort of your evidence. You're having to get to grips with it from the off. And yes, there's an awful lot of front loading and a lot of work, but it would help in you know, these large infrastructure, you know, disputes that we're talking about here, to focus the issues in that way.
Yeah. Okay. Well, look, let's move on, or slightly move on, or move sideways. On the question of oral evidence, Paul, are tribunals, especially with a sort of civil law bias, if I can put it that way, are they right to be as skeptical as some people say they are about the value of oral evidence? In other words, putting it colloquially, oh well, the person will say whatever they want in the box. You know, that's what witnesses do. Not my view, I hasten to add.
Yeah. I mean, I think there's some truth in that. In you know, the sort of that sort of summary of, you know, civil arbitrators getting terribly excited about the witness and sort of the witness stage, and particularly the cross-examination stage, as being sort of the real sort of truth-seeking moment, whereas sort of civil arbitrators maybe sort of, you know, being less enthusiastic about it for the reasons you've said. But you know, I think it's a bit more it's a bit more nuanced than that in reality. But I think it is there is a good reason why civil arbitrators are going to be sort of perhaps sort of less excited about this stuff when we're faced with these sort of 300-page with very, very long witness statements. But and speaking in sort of in favour of that for a moment, I mean, I think that there was obviously the ICC study at the end of last year on sort of the accuracy of fact witness statements and testimony, which suggests, well, on the points that really matter, the accuracy and sort of recollection of witnesses is probably not as good as everyone in the room thinks it is. And from my experience, it's been quite rare to have arbitrations really turned on the fact, the oral testimony, as opposed to what's in the documents. Maybe that's just my experience. I'm sort of very interested to see the other.
You don't see, in your experience, you don't see cross-examination as actually being that valuable.
I think it colours the representation. I think it speaks to the experience and the approach of the witness, and that will sort of will sort of infect the the entire party that witness is representing, if they are manifestly untruthful in what they're saying, or they're tying themselves in knots. Then I think that is significant, and the tribunal will look at those documents and the other evidence through that prism. But again, it may be my experience. I may not have seen it sort of done effectively, but I haven't seen that sort of that defining moment where a particular piece of evidence, piece of of testimony has just cracked it wide open.
You haven't seen Veronique in action.
Clearly, that's it.
I say that because I was looking up the various commendations of Veronique the last few days, and I read that you are a fearless cross-examiner who conducts lengthy and detailed cross-examinations, especially of expert witnesses. Now, does that mean that when you're in a civil law environment, you can't really do your act?
Well, I think one's act gets curbed, Andrew. One's act gets curbed. For instance, you get given 2.5 hours to do your worst with a delay expert or whatever it is. So I think that your timing gets curbed, and so perhaps that concentrates the mind. But I disagree with Paul on this. I'm a big fan of the cross-examination process, be it in terms of experts or factual witnesses. I think it's, well, maybe I flatter myself, but I think it can make a real difference. I think certainly on experts, both judges and tribunals are often having to say to themselves, well, whose evidence are we going to prefer? Because if they don't actually, necessarily either understand or couldn't be expected to understand the actual underlying expert piece, they're going to have to make a decision as to who they should prefer and why. And I think that through cross-examination, you can show whether or not, you can really test that evidence. So I'm a bit of a fan of cross-examination, but perhaps that's to be expected.
I'm with you on this one, Veronique, but where do you stand, Emily?
I see that Samar has also kind of
well, I've got a question which I think ties into what you're just discussing, which is whether in your experience, civil law arbitrators are becoming more open to cross-examination with exposure, and conversely, whether common law arbitrators are becoming more open to an inquisitorial approach through exposure as we go along.
Well, if I give you my sort of take on that, if I may, just based on some recent experience of a mixed panel, and there definitely was a willingness. I was on the panel. I was a common lawyer. There were 2 civil lawyers. There was a willingness there for them to entertain cross-examination without any arbitrary limitations on it. But at the same time, I think I see in front of common law tribunals, a sort of wariness or weariness rather, quite often thinking, well, obviously this doesn't apply to me, but where's this cross-examination going? It's been going on for 2 or 3 hours, and has it really started to scratch the surface of what the real issues are? And you can, arbitrators are not particularly shy, I think, sometimes of trying to push parties, counsel along if they're taking too long. So I think there's a greater sort of willingness there to try and get the lawyers to get to the point.
Yeah, I also think, Andrew, that you do kind of see a blend of the approaches, and personally I find it really helpful when the tribunal asks questions, because then you kind of, well, at least you think you know what the tribunal's at least thinking at the time. So you do, I think, particularly international arbitrations with mixed tribunals, we are witnessing kind of more of a blending of the two approaches, which I think is helpful.
I would agree with that, Emily, because I was speaking to a colleague. They were recounting a story of a recent arbitration where, again, it was a common lawyer on the panel who was asking the inquisitorial questions of a witness, and I think they rather relished the opportunity, in those sort of circumstances. And perhaps this is an exception to what I was saying earlier, but this is one where the case was very much blown open by the sort of the question from the tribunal, where because perhaps because it's coming from the tribunal, so the witnesses are not necessarily, they don't think they're out to get them, they're a little bit disarmed by it. And in that one, sort of the CEO made a sort of a massively significant admission in response to a question from the tribunal, just because they were not expecting that sort of that hard approach. It wasn't a question coming from the other side, therefore they were sort of...
My view is that it I think I share Emily's view here, that it's very useful to get for the tribunal to interject or to ask questions or to query the relevance of something, because it is much better if you're on the counsel team to have some idea of where the tribunal or some of its members may be thinking. I did another case in front of common law tribunal, and I think over about 5 weeks you could have filled about 5 pages of the total number of interruptions. So in other words, one was getting no feedback from the tribunal as to what they may have thought about the relevance of something, the strength of a point, and so on and so forth. But Veronique, are you the interrupting inquisitorial type when you're sitting?
Yeah, I think I am a bit. Well, I hate to sort of admit it, but I am. I think it's probably fair to say that I'm quite merits orientated. So I think that if there's an important issue, I will raise it. And again, for instance, you don't want to sort of stay stuck, not say anything when there's something highly relevant, which both parties ought in fact to be addressing, for instance. You've got situations in which, certainly I've had sitting as an arbitrator, where neither party, for instance, is an English lawyer, but the applicable law is English law. Hence, of course, why they've appointed an English lawyer as their arbitrator. And you might well be aware, for instance, that there was a highly relevant piece of case law or whatever that applies. So, that's part of your role in a sense, as you wouldn't have been chosen were it not for the fact that you might in fact bring that to the party, and that you therefore ought to raise it for the parties. And then it's a very difficult balance, because it's not your role as arbitrator to be making anybody's case, obviously.
No, but there's a difference between making someone's case, isn't there, and raising a point which is obviously relevant to the case, and ultimately I'd have thought would be relevant to the decision-making process.
And questions in terms of factual evidence and expert evidence, I think sometimes there are questions that counsel do not wish to ask because they do not wish to have the answer, whereas of course the arbitrator will want the answer. And certainly when I'm sitting with my counsel hat on, I'm very keen to know what the tribunal's thinking, where the tribunal's going. Of course, sometimes tribunal will ask a question and you'll be thinking, what was that about?
That does happen, yes.
You know, and you're sort of thinking, what have I missed?
But can I just pick up one point from something you said a minute ago? You described yourself, I think, as merits orientated. Now, what do you, and I mean this seriously, how do you describe an arbitrator who is not merits orientated?
Well, that's a good question, Andrew. I mean, I think that, you know, maybe somebody who was, I would have thought sort of more concerned with the absolute letter of the procedure or the letter of the law. You know, procedure would be a good example, because let's say your procedural order says X and you're just going to enforce X. Whereas I think if you're particularly merits orientated, you're going to be much more interested in the underlying circumstances in which a particular situation has arisen.
No,
so you might be more, you know, more willing to, exercise your discretion or something like that.
No, sorry to speak over you. I can see that certainly where you're dealing with procedural points. You know, someone wants the indulgence of the tribunal to do something later than they should have done it.
Yeah.
But in terms of sort of the law, the substantive law, or the law of the contract, does a merits orientated arbitrator reach a result which I don't know how you describe it, but a non-merits orientated arbitrator wouldn't reach?
I don't think so necessarily, but I think that a merits orientated arbitrator might be more likely to ask those searching questions to really try to get to the bottom of what the situation might be. Yeah. And so we'll be looking, for instance, if certain factual scenarios not been presented, or if something is relevant but everybody's sort of keeping it quiet, then that arbitrator might well be asking those questions.
So I wonder if this is fair, and let me ask Emily, whether you want a merits orientated arbitrator or not, presumably then must depend on your case. The less merit it has, but the more law it has, then you want someone other than Veronique.
Yeah, I mean, I don't think Chatham House rules apply, but so I'm going to have to give a very diplomatic answer. I think it does very much depend, but ultimately, quite often, you just want the right result being what is the correct answer under this particular form of contract. So I do think kind of a merits orientated arbitrator is someone that I personally would feel more comfortable with, rather than someone who's kind of a slave to the specific submissions and arguments being made. But I reserve the right to amend that answer in due course.
I think Samar is back, so you must have annoyed someone.
Well, there's a question which is paraphrasing a series of questions, which comes back to the point of civil law versus common law. And it is this: if you're a civil law party with a civil law dispute, what are the advantages and disadvantages of appointing a common law arbitrator, whether she is merits-based or not?
Paul, for you.
It's a very interesting question. And I'll have to put myself in the sort of mindset of a civil lawyer, sort of, approaching this. But I think if you are, in sort of the context of the sort of disputes that we're doing, where it's very often, an owner against a contractor, and where the contractor holds the documents because they're the ones performing the particular contract, and where those getting hold of those documents as an owner is going to be significant, then I could see that there could be some higher likelihood of having a bit more robust approach taken to discovery,
yeah.
with some common law influence on that tribunal. I know we're all going to be interpreting the IBA rules at the end of the day, but as we know, the devil's in the detail in the application of those rules to it. And I've not to say that all common law tribunals will give a take a robust approach and really give order, specific disclosure of particular things. But I think you're probably more likely to get that with some common law influence on the tribunal. That might be one aspect.
Yeah, Emily, you're acting for civil law parties, but why would they choose a common law tribunal?
I do also think that kind of part of the common law approach, if I can call it that, kind of the parties and their counsel are basically primarily responsible for finding and presenting evidence. And I think that is a very good skill set to have. Kind of contrast that with the civil law approach, where it's the judge or the arbitrator themselves kind of investigating the facts. So I do think that there are good complementary skill sets there.
Yeah.
Just thinking about it, actually, I've been doing one, sort of in the last few days where we're at that stage and we are representing civil parties, and the particular contract form that we're looking at here is very much an English-led contract, and there is experience of that, from more experience of that, sort of, in England, frankly, and so we're considering appointing an English arbitrator to that, even though it's German arbitration, but to bring that experience of that particular sort of suite of contracts.
Yeah.
I also think that kind of in construction arbitrations, one mustn't forget that actually what you're actually arbitrating about is a contract with some very kind of often clear or perhaps unclear at time kind of rules and regulations in the contract. So the civil versus common law debate, I think, kind of softens a bit when you factor that in.
I've got one eye on the clock, so let's move on, if we may, to the treatment of expert evidence. And Veronique, let me ask you this, if I may. Is there a difference? What is the difference, do you think, between the approach of a civil law tribunal compared to a common law tribunal when it comes to expert evidence?
Well, I think a mixed tribunal, put it that way,
yeah,
Andrew, it's more likely to obviously favour a sort of hybrid type approach, but is more likely to favour, for instance, presentations from the experts.
Yeah.
And when we, as common lawyers with a solely common law tribunal, very often we have either no presentations or we have a 10-minute presentation. Whereas I think that if you've got a mixed tribunal, and certainly in my experience, you're much more likely, for instance, with an expert to have half an hour or even longer, and presentations which will be, aided with slides and so on and so forth, whilst of course you then have less cross-examination. So I think that's one aspect. What I haven't seen in the mixed context, and it's just my experience, is hot tubbing. I think that that's more likely to come from a common law tribunal, but that just happens to be my experience. You'd have thought that, in fact, an inquisitorial approach would favour that, but I haven't seen it with a mixed tribunal.
I mean, how pronounced is this supposed distinction between inquisitorial and adversarial, if you like? How real is it in practice?
But personally, I don't think it is that real in the context of international arbitration, because we're very evolved. On an international level as to international arbitration, which is really an adversarial process.
Yeah.
And I've worked with lots of continental lawyers, for instance, who in that context of international arbitration, extremely polite and so on, but it's still a fight to the death, so to speak. It's still an adversarial process.
Well, let me ask you this, perhaps I'll give you, if I can ask Emily to give a view on this. You're instructing an expert. Does the expert need a different skill set if they're going to be appearing in front of a predominantly or wholly civil law tribunal compared to when they're going to be appearing in front of a common law tribunal? Are there different skills that they need? And would that influence who you chose?
Yeah, I think the approach does differ, but particularly kind of around kind of issues of independence, because typically you get party-appointed experts in common law, but who owe their duty to the tribunal. And I think it's fair to say that there's a high degree of skepticism of that approach by civil lawyers. But then the civil law approach is different. So if possible, tribunals from a civil law approach, appoint their own expert, and generally in civil law countries, party-appointed expert investigations are viewed by judges with a degree of suspicions. But I do think that, again, this is an area that we see kind of a converging practice where you see the use of both approaches, and international arbitrators on a kind of mixed tribunal do expect to hear from experts presented by the parties. And I think the real issue where you've got to work out what type of expert you need and what skill set you need is where you have kind of conflicting experts reports, where you need to fall back on the experts ability. So that I do think in like really highly complex technical cases, you need to find the person with the appropriate expertise, not necessarily someone who's given evidence in arbitration before. I think that's different, but the real skill is finding someone who's got who can explain really complex technical issues in a way that's understandable. Well, to you, you need to understand your case, but can also explain it to the tribunal itself.
And Veronique, you mentioned a moment ago, I think, hot tubbing. And I understood you to say that that's in your experience less common in a civil law environment than a common law environment. But again, well, let me ask you this, actually, each of you, if I may. I mean, are you fans of hot tubbing? Do you think it really works? I find that the times I've sort of seen it's almost like the person who shouts loudest and longest tends to get listened to more, even though he or she may not be the most expert, as it were. Emily,
I tend to agree with
Paul. No, Paul. Sorry, you go.
Sorry, Andrew.
No.
Go ahead, Paul.
I was just going to say, that I agree with that. That it's very much a skill set of expert conferencing, hot tubbing, and if you've got that sort of real sort of technical expert on something, that in a particularly particular discipline that's sort of where their experts might be or not be readily available, so not in your sort of delay and quantum, but in your sort of technical aspect, then you're not going to find one that's particularly familiar with that. And I just think it's very much personality driven.
I also think kind of hot tubbing, now maybe shot down in flames for even saying this, was a bit of a fad a few years ago. Everyone was writing articles, papers on it, but in practice you really don't see it that often. And I suspect that is because I don't think it is that helpful. I think it is better to have the experts separately address the key issues, because as you say, otherwise I think strong personalities can become quite overwhelming and difficult for a tribunal to manage. But I say that not sitting as an arbitrator myself, but it's just from my experience, it is very similar to Veronique's.
Yes, I mean, I think one of the big things about it is that in order to really work, it needs the arbitrator or the judge, whoever's running it, to really be on top of the expert evidence, and that very often that's why it's not happening. I mean, I think the personality point's absolutely right, but also, given what it requires in terms of preparation from an arbitrator, I think that also explains why we don't see that much of it.
You mean you have to read the papers? Yeah,
and then some.
Now, on that note, tell me if I've got this wrong. My clocks have all got different times on them. I think we've had our hour. Am I correct or am I incorrect?
I think you're correct, Andrew. Yes.
Right. Now, I don't know whether that means that some administrator takes over now and sort of we all dissolve. But before that happens, can I thank everyone who's tuned in, everyone who's sent in a question. I hope Samar understood them and relayed them to us correctly. They were
those which I relayed correctly, hopefully. There are many that I couldn't relay. Apologies for that, but thank you very much for them nonetheless.
Right. Well, Samar, thanks very much for doing that. And as I say, thanks for everyone who did send in questions. Sorry if your question didn't get selected this week, but try again next time. But definitely many thanks to Veronique, to Emily, and to Paul. And of course to London Disputes Week for organising this and allowing us to put this panel discussion on. I'm sure there are 101 people I meant to thank, but I've forgotten who they are. So you're remembered in my heart, if not in my mind. I will, on that note, press the leave button, I think, and say good night to all of you wherever you are. Keep well, keep safe, and I hope that in a year's time we don't have to say keep well and keep safe.